All right, guys, we are live now. So if your microphone is on, then you will be on the live feed. So don't worry, Senator Sidner, you're not on. So just some housekeeping stuff. Senator West had a family emergency, so he's not here. He's going to go. He went home to Baltimore County to attend to that, but he will be able to cast his vote afterwards if it does not change the outcome of the final vote. So giving him permission to do that. And without objection, just wanted to extend that courtesy to him and let you all know that. And without objection, we'll move forward with that. We have 13 bills on the list today, and I think we have one withdrawal.
Correct.
So Senate Bill, was it
124?
124 has been withdrawn, or there's been a motion for this. So we actually have to vote on that, don't we? We have to,
Yeah. Just unbearable withdrawal.
okay. 124. It's not on the list,
It's
no.
not on your, it was just withdrawn.
So we just have to vote on that, though. So.
What was it? It was your bill, courts and judicial proceedings, court fines, payment. Oh, okay.
Okay. So we have to make a motion for that?
I mean, you can just ask for it.
Is everyone okay with that? With it being voted out of withdrawn, voting on the withdrawal? Everyone okay? Okay, good. Great. All right, let's start with. I don't see Senator Huff here yet. So let's start with Senator Elfreth's bill, Senate Bill 43, because we had a good discussion on that, and then there's an amendment before you that you should have received. It's a pretty straightforward amendment, but if council will explain the bill and the amendment.
Senate Bill 43 expands the list of individuals a law enforcement officer is statutorily prohibited from engaging in sexual contact, vaginal intercourse, or a sexual act with to include a victim, witness, or suspect in an investigation during the course of an investigation that the law enforcement officer is conducting, supervising, or assisting with, and a person requesting assistance from or responding to the law enforcement officer in the course of the law enforcement officer's official duties. These prohibitions do not apply if the officer had a prior existing legal sexual relationship with the individual unless an interim, temporary, or final protective order between the parties is in effect. This builds on legislation that was passed in 2018 by the General Assembly, which prohibited a law enforcement officer from engaging in sexual contact, vaginal intercourse, or a sexual act with a person in the custody of the law enforcement officer. Currently, violators are guilty of a misdemeanor punishable by 3 years or $3,000.
All right, so then you've got the, so as we discussed with Senator Castley earlier today, a single amendment does two things. You just walk us through that and then we'll discuss.
This is language that was sent over from Lisa Jordan in response to a point that Senator Castley had made during the bill hearing today. In E1I, it adds language that provides that an officer knew or should have known that the other person was a victim, witness, or suspect in the investigation. And then at the bottom of the page, strikes the word legal and provides, I'll just read the whole thing. The law enforcement officer had a prior existing sexual relationship with the person. An interim, temporary, or final protective order between the parties is not in effect at the time of the sexual contact, vaginal intercourse, or sexual act. And the prior existing relationship was voluntary and free from coercion.
I think the Vice Chair Walserker has something to say, but I think Castley's. Okay.
You're moving the amendment?
I was going to speak on the amendment.
Oh, okay, go ahead.
So I think Senator West had an amendment to this bill in this section, and so I don't want to hold up the bill, but given the circumstances, I think it might be best because he hasn't had the opportunity to prepare his amendment.
Oh, understood. Okay. Oh, I didn't realize that. Was that for this bill? That was for this bill?
It was to this bill, yes.
Got it. Okay. Do you have any idea as to, if he's not here?
Senator West raised the point that he wanted to amend the word active into the legislation relating to investigation to clarify that it is an active investigation. But that's interacting with another amendment here in a way. I'm not sure if we can work it out on the fly. So I,
Okay. When are we voting next? Next week?
Next one.
So in the course of an active investigation. He probably has so in the course of line 1 and 2 on page 3, course of an active investigation, he wants to insert the word active.
are we in the amendment or we're in the bill?
I'm sorry, on the bill. I'm trying to understand the senator's conceptual amendment. I think it's page 3, on the top of page 3, lines 1 and 2. We can't take it if he's not here yet, so I just want to understand what it is. Senator Bailey.
I was just saying, if the police officers could get engaged in this just for a minute, we either have open, suspended, or closed investigations. Using the word active would be muddying the water. It should be if it's an open investigation, right? That would be the terms of it, and you're right. That's a common term for every police department. So,
Fantastic, thank you.
and if we need to, I'd be more than happy to make that amendment.
Okay. Well, let's do this. Since we're going to hold it then, since the senator is not here. My only reservation is I think we all want to move the bill, and this delays it a week. So let's see. Well, we'll hold it. Yeah, it's still early. We'll hold it now, and if we can get a hold of him, get some clarity, we can work it out. If not, no, I don't want to take any of the amendments up yet. So we'll hold it to the end of the vote list, maybe, if we can establish contact with Senator West. If not, we'll just hold it. We'll get some clarity on open, closed, whatever. We'll get the right language drafted, and we'll put it all into one amendment. Does it sound good, Jamie? Okay. If
we can print that up and have it in front of you guys
not tonight, but if we have to delay it for next week, that's what we'll do. Okay, fair enough. All right, then let's do Senate Bill 312, and then right after that, we're going to do Senate Bill 309. I think 312 is Josh.
This bill authorizes a person to operate a golf cart equipped with approved lighting on Upper or Middle Hooper's Island or Taylor's Island on Dorchester County between dawn and dusk on a highway on which the maximum posted speed limit does not exceed 30 miles per hour. The County Council of Dorchester County would designate by resolution which stretch of highways on the islands the golf cart may be operated. The golf cart has to be kept as far to the right of the roadway as feasible, and the driver must have a valid driver's license. So any golf cart operating pursuant to this authorization would be exempt from the general requirement that each motor vehicle be registered.
Favorable, and it has been seconded. Roll call. So we're good. Okay. You want to go through? All right. All right. No one's opposed. It passes unanimously. Okay. Solid work. All right. All right. Now we're going back to Senate Bill 309. Senator Huff. Jamie is counsel.
So Senate Bill 309 authorizes a person to apply for preliminary approval of a permit to wear, carry, or transport a handgun without first completing a specified firearms training course, subject to specified requirements. It is important to note, based on how I just described it, Department of State Police is not authorized to issue a permit until the training requirements have been met.
We've passed this bill, I think, 3 years in a row.
46-0 last year.
It was unanimous, 46-0 off the floor. Same bill, same posture, right?
And everybody voted favorably.
Everyone voted favorably. Okay.
Yeah, I mean, I can explain it real quick.
Yeah, go for it.
So-
Yeah, absolutely.
So
I think I was the floor leader on this bill
yeah,
for 3 years.
we've done this bill, I think, 4 or 5 years in a row now. Actually, I'm going through the process right now myself, which is fascinating. So I'm applying for my my carry permit. And just to tell you, today I wrote a check to the state police for $75. I went and got fingerprinted, which I think cost me, I don't remember what it was, but it cost something. I had to pay him $30-40 or something to get fingerprinted. And then I had to do the training, which cost me a couple $100 and a whole day. You know, it takes a whole day to sit there and you learn and you go shooting. I mean, it's an expensive process. And all the bill says is, before I go do that, just tell me, hey, we're not going to give you the permit, or we will. And if you say we'll give it to you, then I'll go do it all. And once I'm done, you give me the permit. But nobody can get a permit without doing all the training. It's just simply, don't have people waste hundreds of dollars and hours of time when they're never going to get one. It's like getting a advisory opinion from an AG or something, basically.
I'll make a motion for a favorable.
Second.
Is anyone opposed? Everyone's good? All right, it was unanimous. Yes. All right, we'll now go ahead to Senator Wallstreicher, Senate Bill 270. And I guess, Jamie, that's you.
So you should have, I believe by email, received materials on this. I just, for your convenience, included the model jury instructions for indecent exposure. The bill establishes that the offense of indecent exposure includes engaging in an act of masturbation in public. Whether or not a person's genitalia are exposed, violators are guilty of a misdemeanor and subject to the existing statutory penalty of imprisonment for up to 3 years and/or a $1,000 maximum fine. During the bill hearing on this, there was a question about the penalties in D.C. and Virginia. Based on my research, D.C. Code Section 22-1312 provides for the offense of indecent exposure. In D.C., it's a misdemeanor that carries a $500 fine and 90 days imprisonment. In Virginia, Section 18.2-387 provides for indecent exposure. That is also a misdemeanor. It's graded as a Class 1 misdemeanor, which carries $2,500 in fines and a maximum of 1 year imprisonment.
Senator Wallstreicher, were you going to speak on it? I appreciated the intent of the bill, and notwithstanding the grossness of the hearing, the explicit descriptions of the acts that we're trying to prevent, I did have a little bit of unreadiness because of the fact that the name of the law is indecent exposure, and I see that under the language of the bill, we're taking out the necessity of an exposure. And I get the intent because I heard the description of, calling over a child, I think, and showing the child, the genitalia. But I think that we should, at the very least, actually have the requirement of showing, because I fear that this is subject to interpretation if you don't actually have a showing, and it could actually lead to wrongful arrest. Someone's doing something under their coat and it could be assumed that it's that, but we don't know. But without the requirement of showing, I'm not sure that it is properly under an indecent exposure terminology, and perhaps, I'm not trying to interfere with your bill, I get the whole thing, to me, it would make more sense to just say, call it what it is, like masturbation is illegal, we're going to penalize that, but I feel like if we don't have the requirement that the person actually show it, I don't think it's appropriate. I think it's just.
Yeah. So two things on that. I appreciate the concern. To the first part about the kind of subjectivity of it, I think it's a good concern kind of philosophically, but when you look at DC and Virginia, I don't think you've had kind of this epidemic of false accusations of masturbating under clothes or otherwise people being falsely arrested for it. I think they've used that power, the transit police especially, used that power appropriately in the other two jurisdictions, and I can't imagine that would be any different, especially given that, at least for the WMATA system, it's the same officers, that would be any different in DC. To the second issue where this kind of, slight inconsistency to calling kind of unexposed masturbation indecent exposure, I get your concern, and I think I see what you're saying grammatically. I guess the alternative is to create a new crime, and my intent with this was not to create kind of a new crime of masturbating under your clothes or masturbating under a towel. I don't think generally I like creating new crimes. I don't think this committee is generally in the business of creating new crimes. I think the activity itself is appropriately categorized within the indecent exposure framework, even if the words don't exactly match up. And of course, the title of this portion is not part of the law itself.
Actually adding the requirement that the person show it to someone? Well, no, the issue, no, I don't think so, because indecent exposure now is like you're in public and you're exposing yourself, and any random person would see the indecent exposure, would see the exposure. But now we're saying you're not actually, you're not actually showing it. You're just like under your coat doing something. We don't know what you're doing. It doesn't even require that anyone ever see what you're doing or that you show it to anyone. It just could be speculated that you were under your coat doing that. I just think it's broad. That's all. I think it goes a little bit too far, and it's not limited to like the transit. So it could be anywhere that somebody could be like, under their coat grabbing something out of their purse.
Where was this on the bus or the metro?
Circumstances. I have personally seen it. I don't know. I know you ride Metro.
It sounds like behavior on the metro, to be honest. I mean, I've taken the metro. And it's taken a lot. This is why I take the MARC train now.
I hear you. So the language says engaging in the masturbation, whether or not the person's genitalia is exposed. I get that. I'm good with that. I just think there should be some additional requirement that it be shown, intentionally shown. Like, first of all, I don't even like having the discussion. I'm not in favor of it, of the act. I just feel like it's just saying like somebody could be doing something under their coat. Nobody even really ever saw it, because under this, nobody even really has to ever actually see it. And that's, to me, that's not exposure. Just saying.
Well, it's kind of fortuitous that we're having this discussion while it's not live streamed, so apparently we're not live streamed yet.
When I click on it, and I've gotten texts from people that are saying we can't.
Say what?
So it's not the right one.
Oh. Apparently we are being live streamed. People are commenting.
Great.
I just pulled it up.
Actually, I wasn't even thinking about being on the stream for some reason.
I think I got a break with you on that.
Yeah. All right.
I voted for this bill last year, but I think she raises an interesting question because as the law currently stands, you just have to see the genitalia. There's your indecent exposure. So the question when it talks about engaging in an act of masturbation, I mean, how many strokes is that? I mean, are you looking for an ejaculation? I mean, what is, I guess that's the question. What is masturbation in order to break the law? I mean, I've certainly seen young men put their hand down their pants and doing all sorts of, I mean, and not masturbating, but certainly it would look that way. That's what I mean. It does raise a question.
Intentionally displaying it to either one other person or the public at large. Like, what would be the harm with that?
Isn't this like the Brandeis quote about pornography? That's this bill.
But this doesn't require
That's this
you
bill.
to see
You
it.
know it when you see it. You're going to know
This
these
doesn't
guys,
require
the
you to.
testimony, these guys come in, they put a blanket, they're riding around the metro all day, and they're masturbating on the blanket because they can get by it. I think it's readily apparent to everyone who's witnessing this what's happening.
Yes.
And if not, they'll
This doesn't rule out, as Senator Sidnor pointed out, an adjustment. Somebody's making an adjustment. It's not the same thing.
I
And
don't
this-
think that
this
person's
could
going to
potentially
jail over
cover
this. I
But
really
you
don't.
know. You don't know.
Well, I think they're going to have a hard time proving that one in
You
court.
all don't understand. I wouldn't leave it up to interpretation to speculate as to whether, when you're not actually seeing it, whether it's an adjustment or a masturbation. I just think it's a little loosey-goosey, that's all.
So Senator Carter, I appreciate what you're saying, and I think we want to eliminate as much subjectivity as possible, but I don't think it's always possible. And I think it's just a policy call, whether the risk of kind of an epidemic of false accusations is greater than some of the horror stories that you heard the other day from the WMATA folks, from the MTA folks about what they've seen and their inability to properly confront the conduct that they don't want on their systems, and that we don't want, to sit next to, or our children to sit next to. So I think it's just a weighing of the two, and for me, I think the systems are.
So like a whole flood, like a whole epidemic of false accusations, although that's possible. I'm concerned about the one, like, the fact that a lot of young men have a tendency to put their hands around that area, and sometimes just, it's not masturbation, though. And so there should be this component where you're doing it with an intention of bothering someone. You know what I mean?
I think the problem they're trying to solve doesn't involve the exposure of the genitalia, which is why we're here, why the bill's in front of you. But if you wanted to include an element of intention, you could say in this, so looking at the bill on line 15, in this section, indecent exposure includes intentionally engaging in an act of masturbation. Or you could just modify it later, includes engaging in an intentional act of masturbation in public. Would that be helpful?
I could live with that.
Okay. Is that okay?
It doesn't 100% get what I want, but it's more comfortable to me than without that.
Well, where would you prefer intentional to live? In front of engaging or in front of masturbation? In other words, the choice.
I think it's about the intentionality of the act. So in the beginning, like you're intentionally doing this.
Okay, so in this section, indecent exposure includes intentionally engaging in an act of masturbation in public?
I think that's much better.
That's fine by me.
First of all, I mean, I understand that probably masturbation is already an intentional act. However, it takes away the concern I have about someone touching themselves, but it's not really masturbation, and it could even be like an accident.
So,
You know what I mean? Or it even could be a mistake that they really didn't do that, but it looked like they did.
Senator Waldstreicher, in the jury instructions that I provided, actually the second element is that the conduct be willful and intentional as opposed to inadvertent or accidental. So that may create a redundancy in the existing law. I just wanted to flag that.
I appreciate it. I'm fine with the redundancy, and we put mens rea into law all the time, so I see what you're saying.
Sure.
Senator Sidnor.
So if we go with that language that was just discussed, it's my understanding that we're then not, someone's not guilty of this act just by putting their hand down in their pants and making a jerk or two. I'm just asking because, again, I've seen young men doing that to one another in jest. I mean, they're joking around, but I'm just trying to be clear for the record. I mean, I'm willing to vote for it.
All right. We did, and the similar parenthetical. Yes.
I probably didn't even pay attention and thought it was fine, didn't I?
So look, I
Too much time on my
Vice
hands.
Chair, Vice Chair.
I really do think it's. I think, in all honesty, I think it's too broad the way that it is. I do.
So
I
then,
think
just going back,
it's subject to too much speculation and mistake. I do.
so then if are you going to make your offer your amendment to add an intentional act of masturbation in public? Is that what you want?
No, I want a requirement that the person engage in masturbation and intentionally expose it to another person or people in general. But
that's the point
I
of
can't get there, so I'll just settle for intentional.
That's fine. If you want me to offer the amendment, I'm happy to offer it. So moved.
Second.
Is everyone fine with that? Wait, no. I'm sorry, I don't want to belabor this. What would be an unintentional?
Hands down the pants.
But that wouldn't be a masturbation.
But it could be.
If somebody,
You do raise a really good point, though. I got to tell you.
this is, and what if somebody that they're going to come in? A lot of these people may be a little mentally off that are doing this. I'm going to suspect that the vast
All right.
majority are mentally off. Then they're going to come and argue, well, he wasn't intentional because he wasn't in his right mind. Like, how do you?
Well, then he'll go to a mental.
Isn't this? I don't think there's an intentional or not on this. It's either it happened or it doesn't.
I think I'm looking to protect against the adjustment scenario.
It's not a masturbation, though. It's just not.
But it's not like you. But you're acting like that can't be charged.
It
That
wouldn't.
can't be-
You can charge any idiotic thing, but with all due respect, it's not a masturbation if you adjust your pants.
All right, I'm going to suggest I think we're probably overthinking this a lot. I think Virginia, our regional peers and their experience is instructive here, and the Vice Chair has made that point over and over again. We can go around and discuss a little bit more if they're still on readiness, but
Is this the same exact language that they use in the other spots? Well, not that I trust them making our laws for us, but. Huh? Is this the exact same language in the other statute in the in Virginia or wherever? Is this the?
I don't know. This is the same language we used last year in Paso.
Okay. Well, for the record, I don't think that it's good language for a good law, but I will support it because I'm not for people masturbating in public. I just think that this is overbroad, and we might have to come back later and make an adjustment.
no pun intended. You want to clarify between
That's a strict language.
All right, the motion is for favorable. The motion is for. Is there a second? There's a second. Okay, we can do a roll call on this, I guess.
Vice Chair Waldstreicher.
Yes.
Senator Lee.
Yes.
Senator Cassidy.
Yes.
Senator Hellman.
Yes.
Senator Sidnor.
This is with or without the intent. I voted for it last year. Yes. Yeah.
Senator Jackson.
Yes.
Senator Bailey.
Yes.
Senator Carter.
I almost was successful, and Huff had to go and jump in. Well, reluctantly, yes, but it is very poor language. Thank you.
Senator Huff.
Yes.
Chairman Smith.
No more adjustments necessary, yes. All right. We are going to go to, so it passes unanimously. We're going to go to 265. Senator, so that's Josh, right? So Vice Chair Walserker's bill.
This bill expands the scope of purposes for which anatomical gifts not made to a specific person or for a specific purpose can be used to include research and education. The bill of an individual believed, the bill repeals requirements that specified first responders or hospitals conduct a reasonable search of an individual believed to be dead or dying for documents related to their status as an anatomical gift donor. The bill requires a procurement organization to which an individual who is dead or dying has been referred to by a hospital to ascertain whether the individual has made an anatomical gift, to make a reasonable search of any national and local donor registry rather than any donor registry that the hospital knows exists for the geographical area in which the individual resides.
Mark.
I mean, I just put a note of a good bill. I thought we did it last year.
We did.
I don't have anything argumentative, so unless somebody else does, I think we should just move this.
Well, here I go again, but I'm not opposed to it. I think it's a good idea. I just have a question.
Sure.
Which is, so I'm not really that familiar, but right now, somewhere I indicate someplace that I want to donate my organs when I die. And the questionnaire that I fill out or whatever I fill out, it does not ask me if I want to donate it specifically to a person or to education or whatever. So under this bill, they cannot put it into, put my organs into education or research because it can only go for transplantation, but under current law. But under this bill, it will then be able to go for anything. Correct? Is that correct, Jeff? Well, research, so here's my question. Whenever I get my initial application that says, do I want to donate my organs, could not that questionnaire ask me, would you like it to go for transplantation, education, and or research? Because perhaps I really only want to give it to another human being to save their life, and I don't want it to be picked apart and dissected and used for medical.
So
I don't know.
yeah, so there is a way to do that. I'll let counsel answer that question.
Yeah, so these new purposes for which the organs can be used only apply where you have not indicated a specific purpose that they should be used for.
Okay.
Oh, I didn't know that.
All right, I'm good.
I'm still going to vote for it. That's just fascinating to me. I didn't realize that.
Yeah.
I mean,
Although it was a fascinating hearing, actually, every year.
On our driver's license, do we do a general designation or was it specific? So your driver's license is a general.
going to be working on your brain there.
Good luck to them.
There's a lot of studying to be going on in that noggin, Bob. Just kidding.
Gotta bust it his hard head to get there.
Second. Vice Chair Wildstreicher.
Yes.
Senator Lee.
Yes.
Senator Castley.
Yes.
Senator Heddleman.
Yes.
Senator Sidnor.
Yes.
Senator Jackson.
Yes.
Senator Bailey.
Yes.
Senator Carter.
Yes.
Senator Huff.
Yes.
Chairman Smith.
Yes. All right, I want to move to Senate Bill 114. And Josh, if you could explain the bill, and then what I think we're going to do, it's a lot more complicated than initially. I think some of it was revealed during the hearing, but it's than we initially thought. So we may have to have just a small work group on it. I think it's a great idea and concept, but council will explain kind of some of the complications. So go ahead.
So as a reminder, this bill authorizes a person to file a petition for expungement of a conviction under Section 16-303 of the Transportation Article, which is driving on a canceled, suspended, refused, or revoked license. So the issue was raised at the bill hearing as to why the provision of the Transportation Article, which is 16-117.1, which provides for automatic expungement of driving records, doesn't already cover this problem. And the answer is that that provision contains an express exception for any record which is necessary to assess subsequent offender penalties. In other words, any record which is necessary to determine whether you're subject to a provision which says, you know, if you're convicted of this for a second or subsequent time, you have an enhanced penalty. And 16-303 includes such a provision. So that's why I think the individual who one of the witnesses was referring to was unable to have these records expunged because they were necessary to determine perhaps in the future that he was subject to an enhanced penalty for having already been convicted of this offense. So the potential solutions probably include making a change to the 16-303 enhanced penalty provision. So it's a bit of a policy question. So I think it's worth talking it through a little bit more.
And can you just specify, because that then changes the time limitations for expungement, right?
Right, so
right
normally-
now it's 10 years, and you're thinking about dropping it down to, I know 3 years has been talked about, 5, but, so you go from we talked about this earlier, felonies, some felonies will carry a 15-year wait period for expungement, then you got 10 years, and then this would be a big jump to 3 or whatever, So it's a big policy call as an option. So we're trying to figure out some other creative solutions that wouldn't. It just, to me, it creates some it's not symmetric. It's not. Yeah, exactly right. So go ahead, Senator Carter.
Isn't there for counsel? Thank you, Mr. Chair. Isn't there a time period when enhanced penalties apply? It's not forever, right? Is it either 5 or 10 years, maybe?
For some offenses, that's the case, but for this offense, it's just there's no particular time period.
Time when even like DWI, PBJs, you got 10 years or 10 years, I think it is, right?
I think it's 5, but I would have to
5.
double check that.
Okay, so I don't know. So this has nothing. So yeah, that makes sense. I think we've got to first of all, we need to have a time limit on the enhanced penalties for subsequent offender, and then once we do that, then we can adjust this.
Thank you, Mr. Chairman. I guess I have a question about whether this applies across the board for canceled, suspended, refused, or revoked, all of them, or do they each have their own set periods of time?
So it applies for most of those. There are actually several different offenses based on essentially why the license is suspended. So there's a couple of them for which the subsequent offender penalty does not apply, which is, I believe, if your license was suspended because you failed to attend a driver improvement program, which we were ordered to attend, or if you drove on a license that was suspended by another state. So those are the two kind of sub-offenses which are not currently included in that.
Okay, thank you.
In short, it's complicated. So we need to do a small work group because I think it's a good bill to work on. But I'd like to appoint a small work group to come back in a couple of weeks. So do we have any? First, let's ask for volunteers. Is anyone interested in working on this? Sid nor Carter, do you want a look at the ranking minority member? Do you want to assign someone, or do you? Okay. All right. So we've got Cashley, Sidnor, Carter, and then we'll make sure we'll work with council. We'll get the proper departments and individuals together to work it out. Cool. All right. I think another.
We were told that we have to pause voting.
We have to what?
I think we might have to pause voting.
Okay. So we're going to just take a quick pause here for voting because I guess the live stream is not active, and there's an Open Meetings Act question that needs to be resolved. So we'll just pause for a second here. But But we are going to do Senate Bill, I want to do 143 next, because I think there may be some work to do on that. Or is there an amendment being drawn up or something? So, no?
I had an amendment drawn up. Did you get that?
I did not.
All right, so we'll hold it.
I don't know how that's working this year. I mean, I ordered it like a while back. You haven't got an amendment?
No, I mean, it would have come from your office to Sandy and then to me.
They're not sending it to us. We've been ordering them. They're not giving it to me though.
Okay, they might be having some delays right now.
They said that there's a backlog in editing and bill processing.
Well, I mean, I can walk us through what it was. I mean, you know what? It was all I was doing was trying to turn it into building. The Zerker one, I think it dealt with driving. I think it was marijuana in the passenger seat. Yeah, that was the amendment we added when we made it an ounce.
I'm open to
I mean, that's all it was. It's a little concerning on amendments because I've been working a couple that you haven't got any of them yet.
They've got a new system that they rolled out to people are working on it. So I think that they may be having some issues with that.
Yeah, that's.
Mike, I think this is going to come over from the House. Are we on or off? Can I?
Off.
Okay.
Okay, we can pick back up. So, Senator Hupp, do you want to just describe your amendment and then?
You're on Senate Bill
143.
So what I wanted to do, because we'd passed this bill a couple times before, and was it this? Was it this term? Yeah, I think we did. We did with last year Zerkin was here. We did this, and we did it a bunch of the other term too. we went to an ounce, but then the compromise that we went to, which I think worked well because we pushed it out of here unanimously every year, was dealing with marijuana. Basically, a driver motor vehicle may not smoke or otherwise consume marijuana in a passenger area of a motor vehicle on a highway. An occupant of a motor vehicle may not smoke marijuana in a passenger area motor vehicle on a highway. Basically, it's saying you can't smoke marijuana in your car while you're driving, and nobody in your car can be doing it. I think it's pretty common sense. So, I mean, I think that's a good compromise.
All right, so we've got, I think, that amendment and maybe one other amendment coming, so I think, right?
I'm not sure.
Okay, got it. So we'll hold it for the amendment, and then we'll... All right, so we're going to hold 143. All right, next we will move to Senator Huff, Senate Bill 145. If we could give Heather...
Senate Bill 145. This bill establishes that an individual who intentionally prevents or interferes with the making of a report of suspected sexual abuse of a child by a mandatory reporter may be prosecuted at any time for the violation. This bill was passed last year unanimously by JPR and the Senate, unanimously in an identical posture.
Senator Huff, do you want to speak on it, or we're good?
That's all it does. It just makes the crime penalties the same. It just says statute of limitations unlimited on it, so you can come back 20 years later. This is based off of, this isn't, this is like Penn State, where you had to be blocking or preventing the reporting of child abuse.
Yeah, I like it. Second. Is everyone okay? We don't have to do a roll call. All right, good. Unanimous report. So we'll go to Senate Bill... Senator Wallstreicher 159.
That one I had amendment on. Actually, I got a good amendments on that one.
Is it here?
You don't have it yet, do you?
Okay, so we'll hold it. Yep. Okay, so
actually, you're really going to like it because my office talked with your animal control officer, and then he was really good, had awesome standards. He went and checked with everybody else, so it's going to be really good once we get it.
Yeah, what's going on here, guys?
No, it's good. It's good. Actually, the Montgomery County has an excellent training. For once, I want to take something Montgomery County's doing and model it to the
there you
rest of the
go.
state.
Well, every journey's got to start with the first step, all right? You know. Okay, great. So that's being held. We'll hold that for the amendment, and trying to tick off some other stuff here. Let's just. Let's go to Senate Bill 156.
Senate Bill 156 requires a state or local law enforcement agency that removes a publicly owned dog used in law enforcement work from duty to reimburse an individual who takes possession of the dog for reasonable and necessary veterinary treatment provided to the dog. The reimbursements may only be used for usual and customary veterinary treatment that is not attributable to dog abuse or neglect of the dog, and the amount of reimbursement cannot exceed $2,500 during the calendar year and $10,000 over the life of the dog. The bill also establishes the Canine Compassionate Care Fund within the Department of State Police to provide for veterinary care of retired state law enforcement dogs adopted under the bill, and it also authorizes a local law enforcement agency to establish a separate fund as specified in the bill.
On it on the floor. I think we put it back to this posture though on the floor.
That's right.
Yeah, I remember that's right.
I didn't see an amendment that had actually gone on to it.
I think we amended it in committee, and then we had to take, and then
we took it back and fixed it and put it. Yeah, I remember this. Okay.
Run away.
Oh, you're right, because it was a May.
That's right.
Right.
So is there any other saw this last year, same bill. Is everyone okay? All right, is a motion for favorable?
Second.
Oh, sorry, Senator Jackson has a question.
Yeah, question. So we're not doing this the year that someone takes possession of an animal that I had in my agency, and we would customarily take care of everything for a year. This is for a lifetime?
I'm sorry, Senator, I didn't
I'm sorry about that. So this is up to $10,000, is not just the calendar year that the individual gets or the year that the individual gets the animal. I mean, in my agency, if someone took possession of a dog because the handler didn't want the dog,
Right.
then we would pay for everything for a year, and then after that, they're on their own. So this bill is saying
Right, it's over the lifetime.
lifetime. Wow. That's pretty generous.
Right, that's correct. It's $10,000 over the lifetime of the dog.
It's capped at 10, so that's essentially 4 years. Okay. All right.
We'll do a roll call on this, just, so it's been motion for favorable, it's been seconded, and so we'll just do a quick roll call.
Vice Chair Waldstraker.
Yes.
Senator Lee. Yes. Senator Castley.
Yes.
Senator Heddleman.
Yes.
Senator Sidnor.
Yes.
Senator Jackson.
Yes.
Senator Bailey.
Yes.
Senator Carter.
Yes.
Senator Huff.
Yes.
Chairman Smith.
Yes. All right, so Jamie's gonna, I think this is no, this is Josh. This is 208. Good. Senator Huff's bill, Senate Bill 208. Josh, you've explained. Are there any amendments? Do we have any amendments or no?
No.
Okay, good. All right.
This bill prohibits a manufacturer, distributor, or factory branch of automobiles to prohibit a dealer from listing a vehicle for sale or lease on the dealer's website at the purchase price, from coercing or requiring a dealer to list a price on the dealer's website that is different from the purchase price, or from taking an adverse action against a dealer for listing a vehicle for sale at a particular price on the dealer's website.
All right. I think. Oh wow. Okay. There's a motion on the table. It's been seconded. All right. So let's do a roll call.
Vice Chair Waldstraker.
Yes.
Senator Lee.
Yes.
Senator Castley.
Yes.
Senator Heddleman.
No.
Senator Sidnor.
Yes.
Senator Jackson.
Yes.
Senator Bailey.
Yes.
Senator Carter.
Yes.
Senator Huff.
Yes.
Chairman Smith.
Yes. If there was just in the future, I know if that moved quick, but if the senator wants more time to discuss, just make sure you flag me down. All right. Now let's go. We've got, 3 bills left on this? Let's start off with Senate Bill 28, and this will start off set the tempo for this discussion for the, I guess, inclusion of additional professions. Is that you, Jamie? Senate Bill 28, Senator Patterson.
So Senate Bill 28 specifies that the crime of misdemeanor second-degree assault includes the intentional physical injury to another person by a person who knows or has reason to know that the victim is an official, an umpire, a referee, or a judge who is officiating a sporting event. A person who violates this provision is guilty of a misdemeanor subject to imprisonment for up to 10 years and a fine of $2,500, which is the existing penalty for misdemeanor second-degree assault. The bill also authorizes a police officer to arrest a person without a warrant if the officer has probable cause to believe that the person has committed second-degree assault against a sports official as established under the bill. In your voting materials, you should have received jury instructions for assault. Assault can be accomplished in 3 modalities. There's intent to frighten, battery, and attempted battery. But essentially, the issue that was raised during the bill hearing was an inability for people to be arrested after assaulting a sports official during a sporting event. I've also included, because it was a misdemeanor instead of a felony, or because they didn't have authorization to make a warrantless arrest. I've also included information on warrantless arrests. I've included the code provisions that pertain to that. Generally, a police officer can make a warrantless arrest in the following situations. If a misdemeanor is committed in the presence or view of an officer, if the officer has probable cause to believe that a felony or misdemeanor is being committed in their presence or view, and then finally, if the offense is a felony. There are also specified crimes that's under Section 2-203 of the Criminal Procedure Article. And those are included in your voting materials as well.
All right, so then this would, for clarification, like this would include sports officials in with, and I know we've done this over the last like 10 years or so, so we've added in law enforcement officer, parole probation officer, right?
So
and a firefighter.
It's a little bit different than that because the...
you remember we had this discussion, like...
Actually, Jamie's right. For some reason, they drafted this one slightly differently than adding it into the separated out statute.
Interesting, okay.
So it doesn't actually enhance the penalty, it just makes it a warrantless arrest, correct?
Is that the only...
That's correct. It separates it out as still being misdemeanor second-degree assault, whereas assault against a law enforcement officer or correctional official is actually felony second-degree assault. Same incarceration penalty for that, but actually double the fine. This keeps the fine the same as misdemeanor second-degree assault, but in designating it this way, they added it to the list of offenses where you can make a warrantless arrest.
Okay. Jeff, did they draft yours the other way?
Mine is drafted
to include. Got it. Okay. Got it.
Second.
All right. Any discussion before? There's a motion, it's been seconded, but is there any discussion? Senator Sidnor.
The thing that I was listening for at the hearing was I was trying to understand what this gets that the current law doesn't get at, and I'm not certain if I was missing something, but I never.
Ability to arrest without a warrant.
A warrantless arrest. You can, if you hit one selected group of people, which are now a sports official, you get to suspend people's constitutional rights for that one. But if you hit like grandma or a nurse or pick any other group out there, a Boy Scout leader, your wife, police actually have to get a warrant. But if you hit the referee, they can suspend your constitutional right. If you turn around and slug the guy next to you in the stadium, though, they got to abide by your constitutional rights.
Thank you.
Get it?
So if you pass this, you will have 500 bills next year to add every single class of professions and everyone else to suspending constitutional rights to arrest them.
It's a growing list every year. Okay.
The motion's still there, it has been seconded, but I just want to add, Jamie, can you just add that clarification for like domestic violence and...
So there are offenses already enumerated in statute that are provisions for warrantless arrests are made for. That includes manslaughter by vehicle or vessel, malicious burning, malicious mischief under 6301 of the criminal law article, theft crime where the value of the property or services stolen is less than $1,000, crime of giving or causing to be given, false alarm of fire, indecent exposure, crime that relates to controlled dangerous substances, wearing, carrying, or transporting a handgun, carrying or wearing a concealed weapon, prostitution-related crimes, and violation of condition of pretrial or post-trial release under 5213.1. And then there's another section on warrantless arrest in domestic abuse cases.
We've only done this, and quite frankly, this is a debate for another day. I said in the hearing, I think of one of these other ones, the firefighter one, that one was interesting, we voted for. I'll leave it at that. But we only have correctional officers, police officers, and firefighters, which we need to have, in my opinion, a discussion about, because we created a problem with these special classifications, and we're seeing it now. So that's why I move it unfavorable.
The motion's still before us, it's been seconded, but Senator Bailey, want to
Thank you. So I think I got a couple questions, Jamie, real quick. What are the employment standards for these referees, umpires, or legal definition of an official referee or judge? And what's the legal definition of this sporting event? I mean, we are opening Pandora's box here with this and empowering these referees much higher than any other citizen that is there at that event. And what is the event?
So the bill doesn't actually define official umpire, referee, or judge, or sporting event. Those terms, some of them or all of them might be defined elsewhere in the code, which might give an indication as to what those terms mean, unless they were defined in the bill.
Do we have any employee standards for a referee?
Not as it pertains to the section expressly.
nothing in the law.
Right.
Okay.
It doesn't include the coach. So if the coach gets slugged, he doesn't get it. Which, by the way, it's funny that they need all this when it's a crime committed in front of like 100 people. Like 100 people witnessed it. We're not doing it for anybody else. We're going to do a warrantless arrest for a crime that happened in front of 100 people.
Clearly never went to any of my high school games, all right? There were like 3 people there, but I'm kidding. All right. That was really great. All right. A motion's been seconded. Let's just, any other...
Unfavorable.
The motion's for unfavorable. It's been seconded, so we're going to roll it. Unless anyone else has... All right, let's roll.
Vice Chair Waldstreicher.
Yes.
Senator Lee.
Yes.
Senator Casserly.
No.
Senator Heddleman.
No.
Senator Sidnor.
Yes.
Senator Jackson.
This is on the unfavorable?
Yes.
No.
Senator Bailey.
Yes.
Senator Carter.
Yes.
Senator Huff.
For the kill, yes.
Chairman Smith.
Yes.
That was interesting. What do we have left? Senate Bill 91 and what else?
Are you doing, did you ever talk to Wes for Val 43?
Senate Bill 91.
Oh, Lord.
So
that's Jamie. Jamie.
Senate Bill 91 is along the lines of the last bill. It expands the prohibition on felony second-degree assault to include the intentional causing of physical injury to another person by a person who knows or has reason to know that the victim is a bus operator, train operator, a light rail operator, or any other individual engaged in providing public transportation services. Like the existing offense of felony second-degree assault, violators are guilty of a felony and subject to existing statutory penalties of up to 10 years and or $5,000 maximum fine. So this is the same issue, but sort of, as was pointed out earlier, going about it a slightly different way. That's correct. So it would be a felony instead of a misdemeanor. There are differences in the code with respect to what's a felony and what's a misdemeanor. I think notably would be things like the statute of limitation and also warrantless arrest.
All right, so it's actually, so the same issue applies that I just argued on the last. The same issue applies as on the last bill, in that, look, and people should understand this, and that I actually think we really need to look at our assault laws in Maryland. People don't know that. I don't think there's another state in the country that starts off with 10 years on a simple assault. We are like super high on assaults. Most other states, it's like 1 year, 3 year, you start off with. And then we've taken our assault law, which was already one of the toughest in the country, and then we've added on to it these other groups where then we made it a felony on top of that. Nobody should be assaulted. Nobody. But with that being said, now you're going to have it on a case, if you hit the bus driver, it's a felony, but if you beat the hell out of the old lady who's riding the bus, it's a misdemeanor. And so, it's just, where do we end with this? We take this to the floor. You know who wants this badly? Nurses and doctors want this badly. They've come in year after year, and nurses have to be in ERs. They get assaulted, beat up all the time. There's a lot of people this stuff happens to that we could add in here. The mistake that we made, and why I really think we need to fix, and actually we're trying to with that criminalization committee, assault is one of the things that, quite frankly, we should have a tiered assault law. It shouldn't be 10 years for everybody. We should have a tiered 1, 2, and 3 and fix this whole thing and get rid of all these felonies for everybody. Because once we gave it to the first group, it's come in year after year after year for other groups. There's a lot of people that make good cases. The nurses come in every year, and it breaks my heart. I hate to vote against it for the nurses. They get beat up all the time there. It's awful, but I had to tell them it's a 10-year for everybody. And they need to charge. If you charge to the full extent of the law, people are going to get 10 years in prison. To make a felony on top, and then if we add this special group, it's just we could have 10 amendments on the floor. We're going to have 15 bills in here next year to add everybody in. So I think this should be on. Lady Justice is supposed to be blind. We're all supposed to be treated equally under the law. And now we're saying one group is above another group. I don't think that's wrong. I think we've really messed up the assault statute in this state for way too long. And so, with that, I think this should be unfavorable.
Senator Vice Chair Walstorfer, and then Nora and then Cassidy.
So, I think it's a good point, but I don't think it is determinative. We are the ones who draw the line. The idea that there is this slippery slope that we can't determine who to put in and who not to put in, and we're going to have all these bills. Well, even if we have all the bills, we don't have to pass them. That's what the last bill proved, that some people are more uniquely positioned to get this protection than others, and to the extent that we already have frontline workers like our police, firefighters, EMS workers, and correctional officers, that what the transit officers are facing as public-facing employees is not dissimilar from what we see in those other circumstances. Now, obviously, police officers face more danger on a day-to-day basis, but nonetheless, what we're hearing from the transit operators that came before us is that there is an incredible amount of bad behavior specifically aimed at them. Not them just because there's a lot of crime, but them because they are transit operators. Them because they ask people to put masks on. Them because they ask people to do something as outrageous as pay their fare share when they get on the bus. Them, because people go late for the bus and then they start throwing stuff at people when the operator won't slow down for them. And so these guys are in uniquely dangerous circumstances. And I understand the bill as written doesn't require them to be actively driving the bus at the moment of the assault. But nonetheless, that's another reason why this bill is important, because it's dangerous to everyone on the bus when a driver is assaulted. Let me just make a point about the felony versus misdemeanor. Nothing about this law requires them to charge a felony. The underlying offense is still a second-degree assault. If a prosecutor believes it doesn't rise to the level of a felony, they can still charge second-degree assault, and no one's any worse off. But it does provide them the option where something is so heinous that it deserves to be a felony, where the woman dropped a cup of urine on the bus operator while he was driving the bus. That's not a first-degree assault. You can't charge it. There's no death, seriously bodily harm. It's a second-degree assault, but it's not a bar fight. It's not a minor punching. It is something very serious, and we should treat it as such. So I think there's an opportunity here to say to our transit operators that we value them, and that in some ways, because of the abuse they face, they are not dissimilar from the other professions that we separate out. I would love to rationalize our assault statute with you on that task force that we're both a part of, but until we do that, this is an opportunity to say this is the right thing to do, and now is the right time to do it.
Senator Sidnor.
Thank you. When I look at who's already enshrined in the law and looking at our last vote, I can understand why we want to include a bus operator, a train operator, light rail operator. However, the individual mechanic who's not in control of some vehicle as it's moving, I'm hesitant to make it that broad. Again, what I recall seeing was a person that, and I think this was in China, a person attacking a bus driver, and the bus driver trying to fend that person off, and the bus ends up going over a bridge and everyone dying. So when you look at everyone that's already in the law, you have people who are engaged in the protection of the general public. I mean, firefighters or EMS or EMT people, as they're trying to save someone's life. I remember there being testimony that they were being attacked. The last thing you want as you're trying to save someone's life is someone attacking you. Police officers, I get. Parole and probation, I understand. But again, I'm having some hesitancy on any other individual piece of this.
Mr. Chairman, I guess if I could ask the Vice Chair a question, because it seems to me, I don't see where there's any leeway. It says a person who violates this is guilty of this subsection, is guilty of the felony assault in the second degree. So that's where I would, that gives me hesitation as distinct from the last vote. So I don't see the wiggle room here.
The wiggle room is that the prosecutor doesn't have to charge it. In other words, if they charge it and they are found guilty, that this is the penalty.
Yeah.
But if the prosecutor doesn't believe that the underlying criminal activity rises to the level of felony, they still have the opportunity to charge second-degree misdemeanor assault.
Right. Okay. Thanks.
Like the person that's like working the metro, taking tickets, everybody there though, right? This is everybody, not just the driver. And if you make a felony has a ton to say, well, they may not charge. Of course they're going to charge. Anytime we give prosecutors the ability to charge felonies, charge more crimes, of course they're going to charge them. That's their job. They're going to charge as many charges as they possibly can. And okay, you, instead of getting in a tussle with the guy that pushed you behind you on the metro, you get a tussle with the person that's collecting tickets or whatever. That's a felony. The rest of your life, you have huge collateral consequences. Getting a job, with housing, you're borrowed from a firearm for the rest of your life. Collateral consequences forever. There are so many collateral consequences from a felony. You can make a book this thick and still you can't figure them all out. Federally, state, everything else. When you do a felony, that's a big deal. So when I first got out of judiciary, Valerio was real big on that. Taught us, Mr. and Mrs. Lamb. Unless it fits into that, murder, rape, sodomy, larceny, unless it fits into those, you don't make new felonies. Because when it's a felony, it is a lifetime seal we put on you of collateral consequences for the rest of your life. And to say that somebody got in a tussle, whether it be with the old lady behind them or the guy collecting tickets, that's to me is a way overreach. We need to stop adding these new felonies in for stuff like this.
Thank you, Mr. Chair. So I agree with Senator Huff and how, I agree that to create a new felony, it should be for something that really warrants it. I just want to add to what Senator Hedelman brought up, and, of course, with respect to you, Mr. Vice Chair, in reality, every time there is a potential to charge a felony, like right now where we have assault on a police officer, where we've made them a special class and assaulted them as a felony, when you have someone that's arrested and they're arrested for whatever, trespass, and then it's resisting arrest and it includes the assault, at that point, the commissioners where the person is taken before, they are well aware that under the law, that assault on an officer is a felony. And so that impacts the person's ability to get released and what's going to happen with them pretrial. And so we always, and I've heard a lot of arguments this week about, what a jury or a judge is going to decide, but we need to take into account what happens initially. And is exactly why in the other bill we just killed, the people wanted, they weren't satisfied with the idea that a person could get 10 years for assaulting them. What they wanted was the ability to say, I'm so important, I'm so special, that if I'm assaulted, then not only can you get 10 years, but you're going to get arrested, and without a warrant. And so we're giving that ability to do that here as well. I am actually opposed to having any class. I think we've made a terrible mistake going down a wrong road with putting any people in special classes. I mean, it's outrageous that we even have law enforcement officers in that class when they are the ones that carry guns and routinely charge people with assault attached to resisting arrest. We don't have babies. We don't have toddlers. We don't have vulnerable adults. We don't have elderly. It's really outrageous that we would say that an officer, but now to add to like a transit worker, and particularly as Senator Sidno brought up, it's not just even limited to this person that's driving or conducting the machine. It's anyone that works on the premises. That's really going much, much too far. And so I am going to urge this committee to vote against this bill and actually suggest that we might want to take a look at the other special categories, special classes that we've created. Special classes were supposed to be created because of discrimination. Okay, we need a special class because this group, under our society's laws, has a history of being discriminated against, being abused. And we really don't have that type of data here, where there's a history, an epidemic of abuse on these people. And so, again, I just urge us to vote against this and also consider that. And to that end, I'm pretty sure the committee hasn't received it, but I did request an amendment. Thank you.
Thank you, Mr. Chairman. A couple of questions. One, maybe I missed it in the testimony. Have these transit operators had issues filing charges against someone who assaulted them? Yeah, have they had problems with that? And is that why they are here?
Yeah, I think it's more of a deterrence measure than anything else, but I'll let this.
Right. Okay, and then I'm sorry for the sponsor of the bill, and if so, I mean, I guess we can talk about that. But the level of punishment is a challenge for me, as well as any other individual engaged in providing. So those are my questions or concerns.
I think we might be taking a look at that.
Okay.
Senator Castley, did you want to say something and see what we're going to do here?
We're having sort of a more general discussion on these special classes, and I think that it's important. I'm having trouble with this particular bill, but on the idea of special classes, there's certain people that we expect to go out, get up every day or every night, whenever the heck their session start, their shift starts, and walk out and deal with crap. And people try to shoot them, they run from them, we expect them to chase people into dark warehouses and really do all the things that none of us ever want to do, not even once. We tell them to go do it every day. And at some point, society has to step behind these folks and say, we got your back. When you hit Officer Jones, that is not the same thing as the bar brawl you got in last night. You got drunk and your buddies got too rowdy and you hit somebody. This is not the same stuff. Don't even think about it. Don't even think about it. This is big, big league. You swing on that cop, that's big league. Don't even think about it. This is not the same thing as your neighbors or anything. So I think it's with the bus drivers are probably a step too far. I think when we look at the categories, certainly it's not the same thing as a bar fight. It's somewhere higher than that. There ought to be certainly a deterrent. But the felony thing does bother me. I think we got to be really judicious on the felonies. So I'm not going to vote for this one. I think they do deserve special in the ranking, but I don't think we ought to be pulling back on how we look at assaults on police officers and certain other special categories that we've got to stand behind. Thank you.
I was just going to ask if maybe if we might hold it. I mean, I was going to offer the amendment to have it read a bus operator, train operator, or a light rail operator engaged in providing public transportation services. I mean, if that makes people more at ease.
So
Yeah.
the senators asked for a hold,
I'd appreciate the ability to hold it, and we
Okay.
can work on it.
got it.
An amendment to kind of limit it, because I think that public service, that they perform a great public service, especially during this pandemic, but maybe we might want to limit it
Okay.
to, because I think it's a little broad for those who are in that category.
All right, so there's been a request to hold from Senator Sidnor and Senator Lee. That's okay with the sponsor of the bill, so it's going to be held. We'll give them the courtesy to hold. So Senate Bill 91 has been held. Ice. All right, we're going to go back to, we have one last bill to go back to. So it looks like Senate 3, which was this, we had a couple of amendments before us, but Senator West has provided some language to Senator Bailey. All right, do you want to speak to it?
Well, actually, Senator Alfred's provided me language from her and Senator West.
Oh, okay, even better. Okay.
And it says, that they are fine with the word open before the word investigation in Senate Bill 43. And I am fine to offer that amendment.
All right, so that's the clarity that you and Senator Jackson provided. And then, so if that's one piece, and the other two pieces of the amendment are, and the officer knew or should have known that the other person is a victim, witness, or suspect in the investigation. So I'll let Jamie explain the two. Pretty simple, but. Questions about the knew or should have known? All right, Jamie's going to speak to the. Let's do it like this. Just talk about the initial amendment, and then we'll add the open right after that. So, Jamie, go ahead.
Okay, so the original amendment, you should have received a sheet, provides that the officer would be prohibited from engaging in that conduct if they knew or should have known that the other person was a victim, witness, or suspect in the investigation that they were participating in. The next part of that amendment, in the language that Ms. Jordan provided, was to strike, and it might be easier to see it in the actual bill, to strike the word legal in
Line 10 or 9.
line 9 on page 3, and instead add a provision to say that the law enforcement officer had a prior existing sexual relationship with the person, striking the word unless, and instead just saying an interim, temporary, or final protective order between the parties is not in effect at the time of the sexual contact, vaginal intercourse, or sexual act, and the prior existing relationship was voluntary and free from coercion. So in order to meet the exception for the prohibition to not apply, you would have to meet all three of those. That there was a prior existing sexual relationship, there was not an interim, temporary, or protective order, and the prior existing relationship was voluntary and free from coercion. I do want to point out that this isn't language that I came up with or that went through the review process that DLS does. So I would kind of suggest maybe the committee vote if you're going to adopt it in concept, and just to give us some latitude to work with that, but no substantive change.
Senator Cassidy.
The final language there is somewhat troublesome with the coercion stuff. Can we just you guys work on it and do an amendment, we just hold it and bring it back up at the very next voting session? I mean, I'm generally in agreement with what you got. It's that last line about and prior existing relationship was voluntary and free from coercion. I know we struck legal and that's sort of the compromise, but it would be nice to bounce that off a few folks. I just don't want to end up, those are kind of new words that we're looking at, new thoughts, new ideas. It'd be nice to get some good legal minds looking at that. I mean, I think we're really, really close, but I don't want to put words in here that are going to screw us up in other areas, because those aren't words we're familiar with.
I mean, I think your caution is probably, I tend to agree with you. I don't want to hold this bill up, but since we have to go through this review process anyway for the conceptual language, I think you got some pretty good explanation as to why consensual is probably not the right word, but look, I guess so. We'll adopt this in concept. I'm not sure what the procedure is. If we adopt this in concept and then have you all DLS work the language out, then we have it before us again, and then we have to do it again.
Really
I don't know how you
make
do
sense
that.
to adopt it in concept. Just go hold it and put it up for a vote.
Got it. Okay. So let's do this. Let's adopt this amendment, but we're not going to pass the bill tonight.
You wouldn't need to adopt it just to bring it back.
Okay, fine. Fair enough.
You can pull people off the floor on Tuesday.
Yeah. We could do this. All right. Let's do this. Let's have this amendment drafted up, run it through the process, and even if we need to, we can pull people off the floor, like you said, vote on it, just so we don't hold things up. I don't want to hold anything up, just because the session's kind of precarious.
I mean, we can approve the first. If you want to break it into sub-amendments, we can approve and just bring it down to that last. If you want to do that, you can.
So are you talking about
knowing, I think everybody's okay with the knew or should have known language. I don't think there's any problem with that, and there's no problem with striking legal. The issue is what's the language at the bottom. So if you have that 3 amendments, 1, 2, and 3, I think we can get agreement on 1 and 2, and then it's just the language on 3.
Then let me suggest let's adopt those 2, and then also Senator Bailey's amendment with the open investigation.
Yeah, I'm sorry, yeah.
The amendment that's being offered right now is it's all happening on page 3. So line number 1, you're just adding the word in the course of an open investigation, right?
Do you want to do those as individual amendments or all together?
Let's just do it all together.
Okay.
Is that right, Senator Bailey? Yes. Okay. And then we're going to continue on with the, yes.
Actually goes before, in this amendment, goes it before suspect in the open investigation. And the bottom of I, the second investigation.
What line are you on? I'm sorry.
Sorry, I'm looking at the amendment. I'm not looking at the bill.
Okay, it's on the bills where I was going. Sorry.
Okay, but I'll have to.
First one, you do it in the first. So the victim, witness, or suspect in an open investigation.
Okay, all right, so we're going to have an amendment drawn up. Jamie's going to draw it up, and we'll come back and adopt it later. We've got two amendments we can adopt, we're ready for sure, then we'll have the language clarified for the coercion piece. So we'll consider this at a later time, even if we have to come off the floor. Okay? Everyone's clear what's being drawn up? Got it, okay. Okay, that's it. So that concludes voting for today. Let's do, just real quick, floor leaders. We had one change from last time. So Senator Jackson has 181 from last time. That was previously assigned to Senator Castley. Got it. Let's go through here. Senator 145, Senator Huff, you want your bill?
Yes.
Okay. Who wants Senator Kramer's bill? 156. You want, well, you have 118, yeah. Oh, sorry, 118. Yeah, Jackson, do you want 156 as well? The K9? All right. So you've got 156 as well. Senator Wellstrecker, you want your bill? Sure. All right. And Senator Huff, do you want 208? Manufacturers?
Yeah.
All right. Oh, sorry, we held one. Do we have? Yes, we did. Sorry, we did. For an amendment. Senator Wellstrecker, you want 265? Sure. And do you want 270? Happy to do that. All right. Senator Huff, strategically speaking, do you want 309 or do you want someone else to take?
No, Mr. Chair, you always do an able job.
Thanks. All right.
Well, as soon as they see gun,
I know.
people start to get all.
All right, fine, I'll do it. Let's do it. And then who wants 312? All right, Senator Bailey's got it.
That's a big one they gave you, Jack.
All right.
Drive that one off the floor. Don't blow it.
Good stuff. We're out.